All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save this state and this honorable court.
Thank you,
seated.
Good morning. Welcome to the North Carolina Court of Appeals. I am your presiding judge today, Judge Hunter Murphy. To my right is Judge Allegra Collins, and to my left, Judge April Wood. And we are here this morning in the case of Sloan versus America Honda, 21-160. I do know that we do have some outdoor noise that may interfere, so if you can't hear us for some reason, please make sure to let us know. And we'll try to keep the mics a little bit closer and speak a little more loudly. So thank you very much. And we will be with the appellant.
Good morning, Judge Murphy, Judge Collins, and Judge Wood. First of all, I'd like to reserve 7 minutes of rebuttal time. May it please the court, I'm Brad Cutro from Charlotte, and I represent the Honda appellants. This case arises from a single car accident in Haywood County involving a 2002 Honda CR-V. The passenger, Mr. Sloan, died in the accident. Now, that accident occurred in April 2019, when the 2002 Honda CR-V was more than a decade outside of North Carolina's product liability statute of repose. In 2015, a component of the 2002 CR-V, the passenger side airbag inflator, had been replaced at a local dealer, Appletree, so that component was within the statute of repose. This lawsuit followed. The complaint was served with extensive, overreaching, and objectionable discovery. Honda timely moved for a Rule 26C protective order, and the text of Rule 26C and Rule 37 and the official comments make clear that when a party is confronted with objectionable discovery, it may either move for a protective order or serve objections under Rules 33, 34, and 36, but the party is not required to do both. So this case should have proceeded routinely in the trial court. It need not have required this appeal, and this court should not have been required to issue a writ of supersedious to prevent further action by the trial court despite this court's stay. So why are we here? 3 reasons. First, the complaint here ignored and sought to avoid the statute of repose. It made extensive and expansive allegations concerning the original design and manufacture of the 2002 CR-V, claims that are barred by the statute of repose. Second, the complaint named 6 different Honda entities as defendants. It was accompanied by overreaching and burdensome discovery that went far beyond the passenger side airbag inflator and demanded documents and information going back decades and about different kinds of accidents and different failure modes that had nothing to do with the accident in Haywood County.
I've got a question about the protective order over here. Sorry. Is it, so you said that it was timely filed, but I noticed that there was a long period between the time it was filed and the time that it was calendared for hearing. And how does that play into this? And I guess the second part of that is that a protective order is discretionary. So, I mean, why would we even be here? Because the trial court had discretion to allow or deny it.
Well, two answers to those 2 questions, Judge Collins. First of all, the timing was affected. First of all, the parties agreed. The parties were communicating and agreed to conduct a vehicle inspection of the subject vehicle, which occurred in February after this motion for protective order was filed. The parties had hoped, at least from Honda's perspective, that would eliminate the issues and perhaps help accelerate the resolution of the case. It didn't, and after further communications between the parties and, frankly, some scheduling difficulties caused by COVID and the lawyers' schedules, the motions were eventually calendared for hearing in September 25. And in the record, there's communications between the parties. At no point did the plaintiffs themselves initiate a noticing of the hearing, and in fact, what happened was the The hearing on the motion for protective order and the Rule 12b6 motion were both calendared by Honda, and then, just a couple of weeks before the hearing date, plaintiffs noticed their motion to compel and for sanctions in this partial summary judgment motion that they also brought on at the same hearing date on September 25th.
But just to be sure, it wasn't plaintiff's duty to calendar the protective order motion?
No, Your Honor,
Okay.
it wasn't, but it was not a point of concern anyway, because the protective order motion had raised the issues about the scope of discovery that Honda was entitled under Rule 26 and Rule 37 to raise at that point. And that was the first order of business, along with the motion to dismiss, which went right to the statute of repose issue. Now, in terms of the discretionary nature of a protective order, that's true. The typical standard of review here on an appeal from a discovery order would be discretionary, and often there is broad discretion about a protective order. But here, what we're appealing is not the denial necessarily of the protective order, but the sanctions that the trial court imposed, which we submit are beyond the authority and contradictory to Rules 26 and Rule 37. And for the standard of review of those, of the rules, I would point the court to Judge Stroud's decision in Myers v. Myers, where she, in that opinion, held, if the trial court's ruling depends on interpretation of a statute or a rule, review is de novo. If the trial court makes a mistake based upon a misapprehension of the available law, it's an abuse of discretion. And a trial court, by definition, abuses its discretion when it makes an error of law. And we think that the trial court here did commit an error of law, because under Rule 26 and Rule 37, the motion for protective order meant that Honda did not have an obligation at that time to serve specific responses and objections to the Rule 33 and Rule 34 discovery or to the Rule 36 request for admissions. And that's straight out of the text of the rule and the comments. Now,
Let me ask you a question. I'm just trying to think how this would work, Dan. If we went with your approach, that a party can file for protective order and then later bring objections, what would prevent Honda from, instead of filing objections with the discovery, seek a protective order again, this time under 26C, let's say 7, trade secret or other confidential research, development, or commercial information not be disclosed? What's to prevent basically Honda from getting successive motions for protective orders instead of responding to the discovery?
Well, Your Honor, I don't think that's the sequence that the rules contemplate, and let me try to explain how that sequence, as the rules set it out and as we understand it, should work. The 26C protective order motion wasn't directed to what should the scope of discovery be, because we have this statute of repose issues that cuts really through the whole case, because the vehicle was beyond the statute of repose. So that goes to the scope of discovery issue. All right, that's the first issue. And once we get a decision from the trial court on the scope of discovery, then, assuming it's not as broad as plaintiffs want, but it's not as narrow as defendants want, then we know the scope of discovery, and then we can make our specific objections within that scope of discovery, but informed by it. That's the sequence it works. A second motion for protective order would not have been appropriate. In fact, what would happen is we would, and as we intend to, serve objections and responses to the discovery, and then if there were issues and they could not be worked out through a meet and confer, then there might be a motion to compel. But that's the typical process that happens. What was different in this case is this threshold legal issue of the statute of repose, which was really the basis for the motion for protective order. And then that was going to inform and help Honda more narrowly and specifically make its objections to the individual requests. And here there were 74 requests for document production, 38 interrogatories, not counting subparts, 42 requests for admission. And as I said, it was extremely expansive discovery that went back decades when the issues really, in our view, were much narrower. And so that's why under the rules, by applying, to use the verb in the rule, for a protective order, Honda defers its obligation to make specific requests, specific objections to individual requests. And I'm unfamiliar with any case where a party has made successive motions for protective order on the same or similar issues. you would have to frame those in this case or any other. After the protective order motion on the scope of discovery gets decided, you would then, as we have indicated we would, make appropriate responses and objections under the rules 33, 34.
I think you cited some business court law and perhaps some federal law about this tolling, I think, of the specific objections. Am I correct? Do we have any Court of Appeals or Supreme Court law?
We have the text of the rules
So
and the official comments, and that's really where our argument finds its foundation, Your Honor. I think certainly the business court has the experience of staying discovery while preliminary motions are taken up. That is also a practice in the federal courts. But the Rule 37 specifically says that by applying for, Rule 26 and Rule 37 say that by applying for a protective order motion, by applying for it, that the party need not respond to the challenge discovery. And in fact, the comments to Rule 37, Your Honor, said, it says a party cannot remain completely silent, and I'm referring to the official comment to the original Rule 37 that's in our appendix. A party cannot properly remain completely silent even when he regards a notice to take a deposition or interrogatories or requests to inspect as improper and objectionable. If he desires not to appear or not to respond, as here, he must apply for a protective order, not obtain, but apply for a protective order. The party from whom the discovery is sought, here Honda, is afforded through Rule 26 a fair and effective procedure whereby he can challenge the request made. And I'd point out that the analogous procedure for depositions was pointed out, and Rule 37D was cited in Judge Murphy's opinion in the Mace versus Utley case. So this is we sought under Rule 26 a fair and effective procedure to hear this scope of discovery issue in view of the statute of repose issue, and then after that ruling, and as we were prepared to do in the trial court, we would make our specific responses and objections to the individual discovery requests. But and I would say that. Let me ask this
real quick. I just want to clarify. From what I see, I agree that there's the option to do 26C or file objections. Nowhere do I see you can seek a protective order and then file objections later in our case law and or in the statute. I see it as you get one hearing, you bring what you got, because the protective order statute is talking about the discovery, a person from whom discovery is sought can bring the motion for protective order. It's one set of discovery being sought.
Right. That would be duplicative, Your Honor. That would be putting both burdens on the plaintiff and depriving the plaintiff of the benefit, that would put the party responding to the discovery to a duplicative burden and essentially make the opportunity to file a Rule 26 motion a nullity, because the party responding to the discovery would have to do both. It would have to not only file a motion for protective order, but it would have to go to all of the expense and work necessary to identify each of the objections and to respond to all of the discovery simultaneously. And that was the burden that Rule 26 allows us to try to reduce by addressing the scope of discovery problem. And in fact, in a case like this, these discovery requests were extremely broad. They would call for millions of documents. It would take hundreds of lawyer and client hours to do the research to even frame up good specific objections to this discovery. That's the burden that under Rule 26, a party is allowed to, as I just indicated, raise with the trial court and say, can we narrow the scope of discovery before we're put to the burden of coming up with all of these specific objections and responses? Again, there are over, I think, 42 pages of discovery requests here. They're extremely expansive, and if I could just, and again, Your Honor.
Well, I understand the expansiveness of the discovery, and I know you have estimates as to how many man hours and time to get it all together. But I'm just looking at the decision the legislature has made by enacting 26C. You know, all of these things about privilege could have been brought in this motion. We've got the language is including one or more of the following. So the legislature clearly is saying, hey, you can bring this about them being overly broad, you can bring trade secrets, you can bring privilege, you can bring all this in one protective order.
Well,
And to me, that suggests the point of discovery is to get it done quickly and efficiently, not have a piecemeal process.
Your Honor, but from Honda's perspective, it would be inefficient to have to do discovery going back 2 decades in great detail on a vehicle that was outside the statute of repose. That's why, again, the legislature contemplates both. Contemplates initially a Rule 26C protective order motion, and then once that's decided, a party has the ability to then go back and make specific objections. Because the court's obviously concerned about efficiency and those kind of concerns. Here, it would be extremely inefficient, burdensome, and expensive for Honda to have to go through, collect, review, and potentially analyze documents, potentially millions of documents given the scope of discovery, to then determine what specific objections it would have based on a host of appropriate reasons under the rules, including attorney-client privilege and including work product. And here, the trial court stripped Honda of those protections and essentially conflated 2 steps. This should be a 2-step process where initially the scope of discovery can be assessed through the Rule 26 motion in a case like this that A, has got some complexity to it, and B, where the discovery requests are extremely open-ended, extremely expansive, and cover a long period of time. Then, as Honda was prepared to do, the litigant can make specific objections and responses in light of the court's ruling, which it's entitled to receive on a Rule 26C protective order motion, and that serves the ultimate purpose of the discovery rules, which is to narrow and sharpen the issues, and rather than putting Honda or any other litigant to the expense of essentially going through the trouble of responding to all of the discovery requests, all of the responses, and having to simultaneously, without the benefit of a Rule 26C protective order motion, develop very specific, detailed responses that would be required to each of those interrogatories, document requests, and requests for admission. So that was the purpose of the Rule 26C. And I think,
at any point in the motion or the hearing, did Honda seek to reserve a right to come back and be heard about privilege or to be heard about trade secrets?
What we said, Your Honor, was once we get a ruling on the protective order motion, then certainly we'll serve our responses and objections to the discovery as you would in any case. And as in any case, those would be permissible. It would be permissible to raise objections to not only burden, but to attorney-client privilege, work product, and trade secret protection, and that's what Honda was prepared to do. In fact, walking out of that hearing, or figuratively, because it was a WebEx hearing, that's what Honda expected to do. But that seemed to be what the trial court had ordered. The trial court didn't say anything about you didn't serve your responses. The trial court didn't say anything about attorney-client or work product. In fact, if you word search the transcript, those words never come up. There's not even any discussion of waiver of attorney-client privilege or protection, and there's not even any discussion about waiver of responses, Your Honor.
Do you have a transcript site for where, or record site for where you maintain Honda did anything to reserve or indicate its intention to later file objections after the scope has been narrowed?
Your Honor, Mr. Stevens at the argument in the trial court said that Honda would be prepared to serve its responses and objections within 30 days. And in fact, that's what the judge contemplated. If you look at what Judge Pope said, he said, I'll give you 30 days to respond to interrogatories, requests for admissions, and document production. That's at pages, his order is at pages 61 through 64. At no point did he say that those couldn't be served. And in fact, how would it even work if no response was going to be filed to those interrogatories? That's the next step in the process. What the problem was is in this order, the trial court essentially jumped that two-step process into one, and as the order has been interpreted, held that Honda had no ability to raise its attorney-client work product and other protection, other objections that it had planned to do in those responses. But throughout the transcript, it was clear that if the judge disagreed with Honda's position on the protective order, Honda would then, within 30 days, as the judge ordered, serve its responses, incomplete responses and objections to the discovery. And that's how the system ought to work, Your Honor. This case would have been on track, and we'd have proceeded in exactly that fashion in the trial court, but for this issue that arose. Because what happened and the disconnect that occurred in the trial court was after Judge Pope had rendered his order that said, I'm denying your motion for protective order, but I'm giving you 30 days to respond to this discovery. Then Honda submitted an order that was consistent with that. Then plaintiffs submit, and as he had directed them to, he said, you, Mr. Stevens, prepare that order. Plaintiffs' counsel then prepared its own order on the motion to compel, and to Honda's surprise, that's the one the judge entered. And that order included 3 words that Judge Pope had never said and that never came up during the entire hearing. And I think it's important, Your Honor, to look at the hearing transcript, which is not cited at all or addressed at all in the plaintiff's briefing.
But the trial court's always free to change its mind as it's going, and I don't see any argument in your briefs that your arguments were cut short, you were denied due process by being able to argue. There's no arguments there. So even though the judge says something at the conclusion of the hearing, until he enters an order, it doesn't really make any difference.
Well, Your Honor, I would disagree to this extent. As the hearing concluded, there was no indication that Honda's responses to the discovery would be anything other than typical responses in discovery to a set of document requests and interrogatories. What happened in the order, 3 new words appeared without further objection. Now, those had never been said in court. Judge Pope had never said them. They'd never been argued, and they appear nowhere in the transcript. Those 3 words became the basis for this, frankly, this entire appeal, because it was a surprise to Honda. That had not been argued. That had not been anything Honda was on notice of, that this no further objections language was going to be added. And that exceeds the trial court's authority based on Rule 26 and Rule 37, because Rule 26 and Rule 37 don't say that the penalty for filing a motion for protective order and having it denied is to forfeit all your objections. There's no authority anywhere that says that's a consequence of a Rule 26C motion for protective order. In fact, the only remedy that a court would be able to impose on a motion for protective order, if it were denied, is under Rule 26 and Rule 34. The trial court can make an award of fees and expenses on that motion. That's the remedy that the rules would say exists for a motion for protective order that's denied. Not that a party forfeits all of its objections, and that had never been discussed or addressed in court, and it was not anything that was part of the court's ruling. So to that extent, Your Honor, yes, it was a surprise. It was not anything that Honda had an opportunity to address, and that's the reason for this appeal here. And certainly, we've cited, Your Honor, the case that's most closely on point from a state Supreme Court is the Arkansas case that addresses this exact situation under exactly equivalent rules, and it's the Cooper Tire case from the Arkansas Supreme Court. And applying these exact rules, that highest court of that state said, no, you don't lose your ability to object by filing a motion for protective order. That's the first step. The motion for protective order on the scope of discovery needs to be decided, and then a party moves on to serve its responses and its appropriate objections. But you don't forfeit those, and there's no provision in the rules or in the comments to suggest that that opportunity to raise good faith, well-founded objections is somehow forfeited when a protective order motion is denied. And that makes sense because it's an appropriate way to utilize the party's resources. If you've got a good faith debate, as the parties do here, about the scope of discovery, given the statute of repose issue, that's the first issue that the parties need to resolve and get a ruling on from the court. So they did. The court said, I'm not going to engage with this statute of repose issue. I'm not going to grant the relief in this protective order motion. So then you move to step 2, which is say, okay, well, let's pick up and serve our answers to the discovery, the document requests, the interrogatories. But there's no basis in the rules or in the case law to say that by simply taking that 2-step process, that the rules contemplate that you forfeit your ability to do objections. And as cases from this court say, sort of generalized objections really aren't very helpful because ultimately you do need to make specific objections in order to give the trial court the ability to rule on discovery motions and exercise its discretion. Generalities aren't helpful. So that's why the rules contemplate that work doesn't get done and that those objections don't get made until the specific responses are made under Rule 33 and 34. That's when the objections are raised, as they are in every case.
Just a quick question. I know I'm eating into your rebuttal time. So if this motion for a protective order had not been made, and you were before the court 9 months after the interrogatories and discovery had been served, would you have waived your objections at that point?
At that point, Your Honor, we would have, because what the rules say, and this is in the comment to Rule 37D, a party cannot remain silent.
Okay.
That's true. If we had remained silent, if Honda had remained silent and not filed its motion for a protective order, which was well grounded in the statute of repose, then yes, we would have. But we did not. Honda did not remain silent. It filed this motion for protective order under Rule 26, as it's permitted to do, as cases like that Cooper Tire case from Arkansas, and in an analogous deposition setting, the Mace versus Utley case recognizes that language defers an obligation to make specific objections once the protective order motion is made.
But just from my understanding, if the trial court didn't see that motion for a protective order told your duty to respond, then it could have entered this order saying that you've waived your objections. Is that correct? If it sees it differently.
I would disagree because I don't think the rules give the trial court the authority to eliminate all objections based on the denial of a protective order motion. In other words, the protective order motion does preserve and told the time for making specific responses.
But if the law doesn't say that, let's just play devil's advocate. If it doesn't toll it,
that would be the case, but that would be a different set of rules, I believe, Your Honor.
okay, thank you.
All right, I'll reserve the remaining time for rebuttal. Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
Judge Murphy, Judge Wood, Judge Collins. May it please the court, Noah Abrams from the Wake County Bar. I'm here to represent the Sloan family. Your Honors, on behalf of the Sloan family, we're not sure why we're here in the Court of Appeals currently. The defense have appealed 3 interlocutor orders, none of which are immediately appealable. The first 2 orders, as Your Honors are well aware, are discretionary discovery orders are appealable only where the orders affect a substantial right. And no substantial right has been affected. There's only 2 ways in which an order can affect a substantial right, as Your Honors know. It's if it orders sanctions, or if it is, or if it affects a valid privilege. That's a statutory privilege. And the burden is on the defendants to prove a privilege. First, no sanctions were entered. We hear throughout the brief and throughout the oral argument this, frankly, red herring of Rule 37D.
Isn't it a sanction to say someone has waived their objection?
I don't believe that there is a sanction for waiving further objection to discovery. The 37D states, the language of 37D states that if you don't answer discovery, that 37B sanctions are available. And those sanctions are the sanctions that are specifically enumerated under 37B. And then at the end of that, there is the sentence in that last paragraph of 37D that says the failure to act failure to act described in this section including Section 37D, may not be excused on the ground that discovery sought is objectionable unless the party failing to act has moved for protective order. 37B has a number of sanctions listed out. They've got, I believe, 4 of them, 4 specific subsections. It's like B2, A through D. And it basically says that gives you the option of getting a default judgment, holding somebody in contempt, of taking facts as established, or striking an answer. And none of that happened. We asked for it, Your Honors. We did ask for it under 37D, but the 37D sanctions were specifically denied. And if you look at the order itself, which I believe is on 201 of the, is on page 201 of the record, the court said that it had considered our motion for sanctions and found that sanctions should not be entered at this time. All it did was do what every court's allowed to do under Rule 26C and 37A, and look at the objections that were actually before it, and then rule based upon, and then rule and either and compel discovery. The orders also do not implicate or recognize statutory privilege. First, in order for there to be a privilege, it has to be asserted. And this court has numerous, and the Supreme Court has set out numerous ways.
Before you transition too far, I want
Yep.
to just kind of stay on this issue with the language of the order not being a sanction. I was trying to get to the proper page here, but is what the trial court said with that statement, without further objection, is that just a recognition of at least the trial court's interpretation of the interplay of 26C and 37D?
I don't think it's an interpretation. It just said that these are the objections that were made before it, that it was overly broad and unduly burdensome, which this court lacks jurisdiction to consider, to reverse the trial court based on saying, oh, well, we think the trial court was overly broad. And then it said you had your chance under Rule 26C to make a motion for protective order to say, and all they need to do.
Well, I guess
Yeah.
it's right there is where it's a little bit critical to me. With the trial court saying that, is the trial court ordering something, saying that you can't object, or is it recognizing that those objections have been waived? It seems like a pretty thin razor line, but to me, those are pretty important in different things.
Yeah. Well, we did argue waiver in our initial memo, which was included in the supplement. I think all the parties did. And we did say, I think the elder Mr. Abrams behind me had argued at the hearing and had mentioned the fact that it's their burden to bring forward it's their burden to bring forward privileges. The only thing that they brought up is this whole argument that because they feel like they shouldn't have been sued, that they shouldn't have to answer discovery. So I think is definitely a waiver versus a sanction. But it is consistent with North Carolina law. And it's consistent with the Crossman case that counsel for Honda cited in their brief, which says that you must make a particularized, continuous, and timely assertion of privilege to create an appellate right to review the trial court, or to review the trial court's findings.
Counsel, what is your response to your counsel's argument here that the language without further objection was not stated by the trial court and that they didn't have an opportunity to argue against that language?
Well, we asked for it in our brief, and he didn't say that they never asked. The one thing that I would like to correct from counsel is they never asked to make further objections at any point in the brief, in the hearing itself. And I will turn, Your Honors, to counsel for Honda's argument on page 39. And at page 39 of the transcript, Honda says, Your Honor could enter an order on our Rule 26 motion, grant the motion even if you think we need to answer all of the discovery, just give us some time to do that. And he says, but I really would ask that you narrow the scope of it, but give us some time to do it. We will serve those promptly, certainly in no event within 30 days, and we would get this case back on track. They did not say answer or object. They did not say response and respond and serve objections. They said the court could say that we need to answer all of the discovery. And the idea that they said that they had that they came in here and said that there was a single time when they asked for further objections is false. I would challenge counsel for Honda in their rebuttal to point out a single site in the transcript or in the motion to compel where they asked for the ability to seek more objections, because it is not there.
Why would you have to ask to seek more objections if you think that the proper course is that after the motion for a protective order is denied, then you have the opportunity to then make specific objections because now you know the scope of discovery?
Well, that's, if you go to the comments to the rules, to Rule 26C, the comment states, when a motion for protective order is made and the court is disposed to deny it, the court may go a step further and issue an order to provide or permit discovery. And it says, this will bring the sanctions of Rule 37B directly into play. And since the court has heard the contentions of all interested persons, an affirmative order is justified. And here, we put forward the fact that they need to answer our discovery, and we put in our motion to compel that they need to answer it without further objection. They knew that was going to be an issue before the trial court, and they did not respond to it. At the hearing, they did not respond to it in a brief. The first time they asked for further objection, the ability to serve further objections, was after the trial court had already entered its order.
What would the purpose of a protective order be if you have to serve at the same time your specific objections to what is classified here as unduly burdensome discovery?
Well, all they would have to do in this case is say that they believe to preserve their objections would be, in addition, we think that interrogatories number 13712, et cetera, and request for productions number 24568 seek attorney-client privilege. That's all they have to do under the Crossman case. It would be another paragraph. Or they could ask if this court, or they could ask that if the court seeks a denial, they would like the opportunity to come back for more objections. But the onus is on the party making the motion for protective order.
It might be a paragraph, but wouldn't they have to go through all the discovery that they've been asked to give in order to truthfully write that paragraph? I mean, what's the purpose of having those things together?
I mean, the discovery that they've sought is discovery that Honda's answered. I mean, this is not my first case with Honda. It's discovered that Honda's answered countless times before without doing this. It's the first time they've ever attempted this. But all they have, if it is so clear that material calls for privileged information, they can look at discovery requests and say that and put it out there. And it's not, they have to go look at the discovery request anyways to make a good faith argument that's overly broad or unduly burdensome. So they aren't doing anything different. They're not looking at anything different than they'd have to already. We think that the better approach, obviously, would be to go through and do a privilege law. But if a party is going to do a motion for protective order instead, the rule says they have a right to do it. They just need to, as it says, put all the contentions of the parties in front of the court so the court can make a ruling. And here, in terms of the actual effect of this order, the very first page of our discovery requests themselves, if you go to page 74 of the record, it says, these interrogatories request information which is known to you or available to you, and goes on. And then it says, unless such information is clearly privileged. And then it says, if you think it's clearly privileged, here's what you have to do. Serve a privilege log with your responses. So they can go back, for attorney-client privilege, they could go back, could have gone back in October and still asserted attorney-client privilege because it's outside the scope of what we're asking for. We're not asking for Mr. Coutreau's file or Mr. Spencer's file or any of the 7, 8 other attorneys' files in this case. We're asking for information that they produce in every other case we've ever had with them. And frankly, if they had read the discovery request before they filed this appeal, they would have recognized it. It also says so in the interrogatories themselves. If you look at page 81 through 83, all these communications, which we recognize could be read broadly enough to encompass attorney-client privilege. So we put out there specifically, for any communication you contend is privileged, please expressly assert the privilege and describe the nature of the communications not disclosed in a manner that, without revealing information itself privileged or protected, will allow the other parties to litigation to assess the claim of privilege. So they can still do what we ask them to do. Nothing about the order changes the words in the interrogatory responses. They didn't strike that language. The court didn't strike that language. They could still go back tomorrow and serve a privilege log. Now, what it does do is it takes away the mulligan. That they better be right for what they withhold, because there's been a 37A order. And so if they withhold something and claim it's privilege and it's not, it's already been ordered to be produced subject to a 37A order, and so it brings sanctions into play. But that's the only difference. And so for that reason, it doesn't affect a privilege. And they didn't assert trade secrets. And in these cases, what is done is either they ask the court or they ask us for a confidentiality order governing how documents that constitute proprietary information is maintained in the litigation. So if they give me a document, they stick confidential on it, and then the court has an order as to what confidential means. Honda knows this. We've entered into consent confidentiality orders many times with them in the past. We have a case with them currently pending where there's a confidentiality order. And in this case, I asked them, and it's in the record in the documents that Honda produced, I asked them 5 or 6 times in writing, hey, can you just go ahead and get us a proposed confidentiality order so that we can get the document production and get the case going? If they had a valid basis for withholding documents altogether from production, in this case due to trade secret privileges, why didn't they bring it up in the motion itself? It would have taken 1 sentence. Why didn't they bring it up in response to our motion to compel when we said that we asked the court to respond without further objection? And then why didn't they bring it up at the hearing when we said they did not serve objections? And so because the court didn't enter sanctions and the orders don't affect any assertions of privilege, these orders do not affect a substantial right, and appeals have to be dismissed.
So, just I'm trying to process on the fly this argument that I didn't see as really being the argument you had in your briefs, and I apologize if I misread your brief on that. But is your argument basically that on the issue that could give appellate jurisdiction for substantial right, it's actually moot because they still have the right to assert a privilege?
They have the right to assert attorney-client under the very words of the interrogatories. Attorney-client and work product privileges outside the scope of what we're asking for. So yes, as to those. I do think that the trade secret has been waived, but the trade secret privilege, frankly, especially when the entire argument that they're making is these documents are so old that it would be so hard for us to go back and find them. There's no trade secrets in this case that would preclude production to us. Now, they may ask us for a confidentiality provision in terms of how the documents are maintained, basically, that we've got to maintain control of them. We can't put them out there on the internet or go try and sell them to Nissan. But Nissan wouldn't want a 2,000 documents from this range anyways. So, but that's the only matters at issue is trade secret privilege. But what it does mean is that there is an order. And So if they do say, we're not going to give you this document because it's work product, and it turns out it's not, then the court has the power to grant sanctions under 37B, and those sanctions are significant.
Can you answer a question? So I see both in the transcript and on the record at page 202 that Honda's motion for protective order was allowed in part. Is that correct?
Yes, and what they did was they did
Granted.
exactly what Honda asked them to do and give them time to answer within 30 days, answer all the discovery within 30 days. They just gave them, and if Honda wished that their attorney had said, answer and object to all the discovery, then we could have argued again. We could have said, hey, they shouldn't have the right to object, and then the court could have ruled. But they didn't say answer and have the right to object.
But I'm just curious, how is that granting a protective order when they just have to respond to all the?
Well, what they're saying is, there were requests for admissions that had the protective order been denied, that would have been overdue. If they said you can't respond to the request for admissions, the case, I mean, it would be a damages case at that point. And so if and if they deny the protective order, then you'd be looking at a situation where the discovery itself was 10 months overdue. They'd have to produce it. You know, he could start saying you get cost blank per day until you produce it to them because they're already 10 months overdue. And so the effect of the grant of the protective order is basically like, all right, you got these objections, you've got 30 days, or you made your objections that you made, you're stuck with the objections you made. I'm denying the specific objections you made, but I'm giving you a second chance to answer the request for admission and to answer the discovery and produce these documents before I grant, and not give sanctions for the failure to produce over a 10-month period. So that's the effect.
That seems to conflate a motion to compel with a granting a protective order, but maybe I'm wrong.
He granted both, and then if you look at 26C, the language of 26C itself, there's that final paragraph before it goes to D, and it says, if the motion for protective order is denied in whole or in part, and this was denied in part, the court may, on such terms and conditions as are just, order that any party or person provide or permit discovery. In this case, he denied it in part and ordered that they provide and permit discovery. So they did exactly what the rule allows them to do. The court could have awarded us costs since he denied their actual objections as to overbreadth, but the court declined to do so. And again, the court says that the comments say, since the court has heard the contentions of all interested parties, an affirmative order is justified. So the court was allowed to rule on the objections in front of it, deny those objections, but give them a second chance to answer the request for admissions, so they wouldn't be, so we wouldn't be able to get summary judgment against them, and then have the case go on, but say those are the objections that you made, those objections are done, and you had your 10 months to make other objections, and you didn't. And Your Honors,
On the request for admissions, wasn't there still some time, about 2 weeks, left after the order, that
No.
if the tolling comes into play?
No, the request
If I
for
remember, wasn't
admissions
it
were,
16 days after service is when they file the protective order, and then it's so they'd have 14 days left before they're deemed to be admitted?
I didn't look at the whole tolling situation, but I guess if it did, then he gave him 15 extra days. So that was still relief. They didn't have to file, it says 16 days to 30 days. That would still be granting him relief. But for the purposes of this, he did grant the extra 30 days.
And just so that I'm clear, even if he waived, even if Honda, not he, even if Honda waived any objection allegedly for privilege, their response can still allege privilege based on the wording of your interrogatory. Is that what you said to me?
Yep. Yes, Your Honor, and I would say especially for attorney-client work product, because that's put out there, but, I mean, they could allege the privileges, but again, they need to be very, very, they would need to be very conservative as to what could constitute a privilege, because if the court declines, feels that it's not privileged, then they would be subject to sanction. Your Honor, this appears to us mainly to be a thinly disguised attempt to get at obtaining a de novo review of something that the court has no power to review, and that's the denial of the 12b6 motion. And the Supreme Court clearly holds that this denial of the 12b6 motion is an interlocutory order from which no appeal may be taken. And so they took this gamble. They filed this boilerplate motion for protective order without asserting any privileges, and refused to respond to the valid discovery requests or make specific objections when they're already having to review the discovery to make their motion for protective order, which again cited some of the requests themselves, and they lost that gamble. And to answer Judge Murphy's question earlier to my colleague about what would happen, if this court were to reverse the trial court and reverse prior precedent from this court, this will happen in every case. No party is going to respond to discovery without filing a generic motion for protective order based on a 12b6 motion and then just sit on the motion. I mean, it's going to happen every time. Every party, I mean, we're attorneys. Every time that we take on a case, we think our client's right. And so everybody's going to say, well, I've got this colorable defense, this colorable 12b6 defense, and I want to have that heard, and I might file the motion, I might set it, I might not. And then you have it 10 months out. And then they could then file this motion for protective order on this basis as, oh, well, we don't think that there's a case, or if we do have a case, if there is a case, it's not as good of a case as the plaintiffs think, so they should have a new set of discovery, have that denied, then appeal. And appeal based on something like this, where the court says, all right, well, I've had enough, and then get that reversed, and then file a second motion for protective order and not respond, say for attorney-client privilege, and then have that come up, get remanded back, and then file a third motion for protective order that says, oh, well, this also calls for a work product, and then appeal that, and so on. It would take 10 years to get any kind of medical negligence or product liability or any kind of case that has any kind of complexity to it to trial. I mean, how many times has anyone seen in the last, I haven't been practicing that long, but I've been practicing a while, and I've never seen an answer that doesn't have a 12b6 motion in it. And there's a reason why this court and the Supreme Court required that parties specifically assert privileges or assert objections at the trial court level the first time so the judge can rule on it. And that's fairness to the parties first, and that requires that the litigants, that Mr. Coutreau and I and his firm and his co-counsel and my firm and my co-counsel know what's at issue, and that we can argue it, and that we can argue everything having to do with that discovery dispute at one time. And then secondly, this court and the North Carolina Supreme Court require it for the purposes of judicial economy, because we don't want to have an appeal over whether or not 12b6 should have been denied, and then come back and have an appeal over whether the attorney-client privilege was properly implicated or whether or not work product is or trade secrets. You have to do it all at once, and that's what the cases say. And that's the reason why parties cannot switch horses and make new arguments like Honda's doing at appeal, because this court's, it's said all the time that this court is in the business of error correcting, of correcting errors. And the errors that this court is to correct is a legal error by the trial court. It is not a potential strategic error by a litigant who wished that their attorney at the time had said, if the court awards to answer or object, then we'd be fine with that. You can't err a trial judge can't err by failing to consider arguments that the allegedly aggrieved party didn't make. And a trial court can't err by granting relief that the aggrieved party specifically requested at the hearing. And that's even if the request was made in the alternative, that they wanted something more, but said, if you aren't going to do that, well, at least give us this. Simply put, the purpose of this court is not to give an appellant, no matter how large, or no matter how many times they change counsel, the chance at a do-over. And that is what Honda is asking for. And then we discussed the, I guess, just before I go, because I've only got a couple minutes left, are there, I'm prepared today to discuss the 12B6 denial, but the council hadn't raised it at all. Happy to.
You did reserve some time, so if you'd like, you've still got 2.5 minutes.
Okay.
So if you'd like to use your time, that may be worth your while.
Okay, and I do want to say that for that one, the 12B6, it's clear, you can't appeal 2 unappealable orders and then get the right to appeal a third unappealable order just because you shouldn't have appealed 2 other orders you shouldn't have. But I'll have, to the extent that there's any substance on that, substantive allegations, we'll discuss it.
In the past cases where we have gone ahead and addressed, for judicial economy and exercise basically pendant jurisdiction on those issues, for any of those cases, were those separate orders or were those combined orders, if you know?
I believe that they were combined orders, but I'm not 100% sure on that. I believe they were, but in that case, the other orders had affected substantial right. And I know that this court, in cases that we've had where there's been a 12B6 and a 12B1, say in a claim against a DHHS employee, the court hears the 12B1, the one that there is jurisdiction for, but not the 12B6. And that's, but in terms of the substance of the statute of repose and all that, I'll reserve my timing if he brings any of that up.
Thank you, sir. Give me just one moment before we start with the appellant.
You can do it however you want.
All right, court will be with the appellant, and we have also decided to give you an additional 3 minutes added to your time to address some of the nuances that came up regarding the language of the discovery request and how that may impact the appeal at this point.
Thank you, Your Honor. And my timer says 4:07. Does that mean I have 7 minutes?
Yes, sir.
Okay, thank you, Your Honor. To begin with, I have to go back to the language of the rule and the comment. And the official comment to Rule 33, for example, which is part of the statute that the legislature adopted, says, a responding party who believes that some parts or all of the interrogatories are objectionable may choose to seek a protective order under new Rule 26C or may serve objections under this rule. Unless he applies for a protective order, he is required to serve answers or objections in response to the interrogatory, subject to the sanctions provided in Rule 37D. What that says is if you file a motion for protective order under Rule 26C, you preserve your ability later on to file both answers and objections to the discovery. That's what happens in every case. I've been practicing law for a while, and as I sit here, I cannot think of a case where I've responded to a set of interrogatories or document requests without a single objection. That is a customary part of a response, of an answer to document requests and interrogatories. And that's what Honda always envisioned doing once it had obtained the court's preliminary guidance on a Rule 26C motion as to the overall scope of discovery.
So just so that I'm clear, that the verbiage here in the transcript where Honda is asking to respond, it's your contention that that response would encompass objections?
Absolutely, Your Honor, because that's a response to discovery. And what's ironic here is that under plaintiff's view of the case, under Appellee's view of the case, Honda disadvantaged itself by moving for a protective order on an appropriate statute of repose question. And that somehow by doing that, we have have foreclosed and forfeited our opportunity to file a routine set of discovery responses that would answer the interrogatories and answer the responses or the request for production with appropriate objections, including attorney-client privilege and work product and trade secret. Before I forget, Judge Murphy, you asked a question about sort of the timing of when our motion was. The motion for protective order was filed with 2 weeks left in the period for which that Honda had to respond to all of this discovery. So we filed that motion for protective order with 2 weeks left. Now, we still believe that that was an appropriate motion for protective order and that Honda had the choice to do that rather than, and serve a Rule 26C protective order motion, as the rule says, instead of filing responses and objections. So, but to your point, there was that 2-week period.
Let me ask real quick, and then I'd like to hear you on the other issue and let you finish out. But looking at record page 163, the first and second paragraphs, and this is in the defendant's, or the plaintiff's motion to compel. It seems pretty clear to me that the issue of whether your responses would be with or without objection was before the trial court, looking at paragraphs 1 and 2 in that request for relief. So at that point, isn't that where there should at least been some mention or request with the trial court to be able to respond with objections?
Your Honor, that did not come up. That specific language or request from the plaintiff did not come up at the hearing. It's not in the transcript, and it was not in Judge Pope's oral ruling at the time, this without objection. So it was not even discussed during the hearing. So that's why Honda reasonably didn't anticipate that would happen again and didn't address the idea of objections. But I think the larger point here is that the rules don't permit that as a sanction. The rules don't permit that if you get a protective order motion under Rule 26C denied, that a sanction that the trial court can enter is that you forfeit all your objections. That is the point of the alternative options that a responding party has. And of course, this cuts both ways, irrespective of plaintiff and defendant. That cuts both ways. You have the ability to raise this protective order motion and then make your specific objections and responses. And let me address the point that my opposing counsel made about their desire, their language that said they're not seeking attorney-client privilege, which doesn't necessarily address work product and other protected documents, but that's what they said. But at the same time, they said you have to file this enormous privilege log. Now, privilege logs are customary. You need to do those, but there's a big difference between preparing and filing a privilege log for 1 million documents versus 100,000 documents. That's why we raised the protective order motion. That's cold comfort, particularly where the definitions in their discovery include in the definition of Honda, you, the responding party, attorneys. So there are serious attorney-client privilege and work product issues here. Those are the objections that it's important to Honda to preserve and to have the opportunity, as it always envisioned, in asserting those in a specific, appropriate way under the rules in response to the specific interrogatories and document requests. It shouldn't be a disadvantage to a litigant to file a Rule 26C motion on a good faith basis, like the statute of repose, and then find itself disadvantaged later on. That's not a sanction that the court is authorized under the rules to award the forfeiture of any objections. Now, so if they ask for it, Judge Murphy may be so, but I don't believe that under the rules, forfeiture of all objections is a penalty that can be imposed in connection with the denial of a protective order motion. Now,
but shouldn't this then, with this language here in 163, since there's an issue before the trial court, shouldn't you have been arguing to the trial court that you can't do this without objections? We still get to make our objections. And to me, it's clearly before the trial court
and Your Honor,
motion.
what I can say is that in the position of Mr. Stevens arguing as he did, I would understand that when we promised, yes, we will get you answers to these interrogatories and document requests within 30 days, that contemplated objections. And nothing Judge Pope said at the hearing indicated to the contrary. That was something that was in a brief that was filed several weeks before, but it never came up at the hearing. It never came up in the judge's oral ruling, and it was a surprise to Honda when it was put into the plaintiff's order. It was never part of the argument that happened, and it was an extensive argument. There are over 60 pages of transcript. So for that reason, I think it's understandable the litigant would expect that answers to interrogatories, which Honda was promising, would include objections. And finally, to the sort of slippery slope argument that we heard there. First of all, we're not asking for any change in the law. The rules we're quite citing the 1975 comments when these rules were enacted. We're not asking for any change in the law. And of course, protective orders have not been abused in our courts. Why? Because this is a very unusual case where you've got a product liability case on a vehicle that's over a decade outside the statute of repose. That was why, in this case, there was a good faith basis for the Rule 26C motion. We are willing and have always been to serve responses once we've gotten the court's decision on the Rule 26 order or motion, but those need to include the ability to make appropriate good faith objections, including attorney-client privilege of work product. That's what it's going to take to get this case back on track, and that's the relief we'd ask the court to award us by vacating these orders, ruling that Honda's got 30 days to respond with appropriate objections under the rules, 26, 33, 34. And of course, we believe that going forward, that's the procedure that we should follow, which is followed in every other case. It should not be a disadvantage to a litigant to have been filed in good faith a Rule 26C motion and somehow be deemed to forfeit all of its objections. That's not a sanction that's provided for under the rules.
Quick question. So the order that drafted for the discovery, for the protective order, the Honda was asked to draft it, correct?
Correct.
And this is not the order that Honda drafted, correct?
Correct.
And was there any, and forgive me if I don't know this, any motion for rehearing or any going back to the trial court?
There was an email attempt to get the judge to address this. The judge simply said, I'm satisfied with my order, having reviewed this, did not ever specifically engage with and say, yes, I meant for Honda to waive its attorney-client privilege and work product. Yes, I meant for Honda to waive any objections. The judge just, did not engage with that, and that's why we're here today.
The defendants did not file any motions asking for it to be reheard, just the email correspondence.
The email correspondence where the judge indicated he would not reconsider.
Judge Wood, anything?
I do not have any other questions.
Thank you.
Thank you for your time.
Thank you both for your arguments. Mr. Storr?
All rise. This session of the North Carolina Court of Appeals is adjourned.
Same good? Yeah. Good to see you. Instead of Charlotte. That's right.